Good afternoon to our CLA family, clients, community partners, and friends. Welcome back to our 11th live stream. Our focus today is going to be on developments related to the Paycheck Protection Program and other lending programs. We are grateful to have all of you today, and as always, your health and safety is our number one priority. I do want to start today's session with a couple of housekeeping items. First and foremost, as always, we want you to be part of the conversation with us. We have professionals in the chat that are eager to respond to your questions today throughout our entire session. And again, following the session, to the extent you still have questions, we encourage you to either submit those questions below via the dialog box, or you can follow up on our COVID-19 resource page at claconnect.com. So we have had a ton of activity on the PPP and other lending programs in the last few days, and the activity has focused on legislation, expansion of the program, new guidance issued, and of course, media buzz. So we have three speakers today that I want to introduce to help us guide these topics. So I want to welcome back Omar Nashashibi from the Franklin Partnership. You may remember that Omar is a lobbyist out of Washington, D.C. We also have Jack Rybicki from our real estate group, and he frequently has been in these live streams to talk about the PPP and other lending programs from the borrower's perspective. And then finally, we have Todd Sprang with us. He also focuses on lending, but frequently he's focused on the financial institution's perspective. So welcome to the three of you. I look forward to our conversation today.
Thanks, Leslie.
So a roadmap of what we're going to discuss today. We're going to start with Omar and talk about some updates from the Hill, and then we'll pivot to Todd and Jack to discuss the latest guidance, FAQs, and also what's the activity that we're seeing with the lenders and the borrowers, and what are we hearing from our clients. And then finally, we'll close with any questions in the remaining time allotted. So Omar, let's start with you. It has been a busy last several weeks on the Hill, but these last few days have been especially busy as well. Talk a little bit about the legislation that was signed on Friday.
Thank you, Leslie. Yes, the ink wasn't even dry last week until before we started lobbying on the next bill, which we're going to start calling CARES 2. And we'll give an update on that here in a second. But yes, on Friday afternoon, President Trump did sign in what we're calling Phase 3.5 into law. That's the measure that included $75 billion for hospital, another $25 billion for testing, and of course the 3P program, the Paycheck Protection Program loan that is 100% guaranteed by the Small Business Administration. Another thing that they did doesn't receive as much headlines. The EIDL, the Emergency Injury Disaster Loan Program, they did provide another $60 billion for that on top of what was already provided under the previous CARES Act. Of that $60 billion, $10 billion will go towards loan forgiveness entirely, so it'll be in the form of an actual grant. So they're allowed to give up to $10,000 under this program, and they were awarded $10 billion to be able to do so. However, the challenge there is it's not back up and running right now, even though the 3P program did come back online. The numbers that we've got as of Friday on the EIDL show us that there were about 38,000 loans processed at a valuation of just about $7.98 billion. So even if you add that on top of the 3P program, it shows that there's a great big demand out there for capital for the small businesses throughout the country. On the 3P program, as many of you already know, it opened yesterday at 10:30 Eastern Time on Monday, April 27th. Again, by 3:30, the SBA, the administrator tweeted out they had already received over 100,000 approvals in the process just in that day. And so that tells you, we went from 10:30 a.m. to 3:30, and in that time they had already approved 100,000. So that tells us the $310 billion that they provided in the second tranche, not quite sure how long it's going to last. The Treasury Department is telling folks up on Capitol Hill that, yes, this second tranche should now cover all 60 million Americans that are employed by small businesses. But just Hill staff just aren't buying that. And so what we saw, and I know you'll talk about this a bit more, but Sunday night and then again yesterday, SBA say that they're going to just limit the amount of loans that they're going to permit to be processed. So for example, they're going to require some of the larger lenders especially to pace themselves and only allow maybe a certain set amount of loans through per hour. And we've already started to hear some complaints from Capitol Hill, but frankly, the reason we're hearing that they did that is they were concerned certain regional lenders that were more sophisticated were going to be able to process more quickly than others. So Democrats in particular that were looking at the under 50 billion in assets and remember under 10 billion in asset set-asides, that's a part of the reason why we're hearing from here in Washington why they're trying to slow down some of that pace, because initially reports were coming from people we're talking to here. They were going to run out of funds by the end of Wednesday. And that's a real concern, obviously, for those of us that work on it and many more that rely on it. So that's why another reason them slowing this down, it should hopefully help at least now get us through the end of the week, if not early into next week is our understanding. Because right now, the Secretary of Treasury is telling sources on Capitol Hill that this is going to be it. There's not going to be another round of funding for the 3P program. But again, we'll see what Congress has to say about that, especially as we're seeing demand remain so great. And that brings us to the timing for another bill here. And what would they do, especially if we do run out of funding here shortly? We are still hearing that the goal would probably be by Memorial Day to have the next CARES 2 or Phase 4, however you'd like to refer it, done. The challenge is the House of Representatives just said they will not be returning to the nation's capital next Monday, May 4th, as planned. There are apparently 11 construction workers in one of the Capitol office buildings that have been confirmed with COVID, and the Capitol physician has advised both the House and Senate to not return. So what kind of delay does that create? What are some of the challenges? But we've already seen the horse trading already begin, even without them here. And we've heard that Democrats want state and local funding that might be capped with some restrictions. And McConnell, really, the Senate Majority Leader, seems to really want to insist on some kind of business liability insurance to make sure that the employers and employees are not held liable, and versus some claims that we expect some pushback from states here and there, but that is something that's also on the table. But lastly, from the tax standpoint, we do know for sure that Democrats are trying in the House to get a number of Republicans to support and publicly go along with this legislation. The top tax writer in the House Ways and Means Committee, Richard Neal from Massachusetts, has been floating around town the possibility of making 100% business expensing permanent. As you know, under the TCJA, it's more of on a temporary basis where it begins to phase out in a couple of years. Well, right now he is floating to Republicans. Maybe what we can do is get rid of the limitations that are coming in a couple of years in the hope to bring the business community along. So we're starting to see different proposals getting floated around. We know Democrats, progressives, were not happy with the net operating loss written the way it was to cover losses in 2018 and 2019. So we're watching those things to bouncing around pretty closely, because according to SBA sources right now, and I think many people heard what Mnuchin had said, there's going to be another look back at the 3P program and how that's going, whether it's going to be the audits that I know you'll touch on of companies with more than 2 million in loans. We still don't have any further guidance on that, but we'll probably get some clarity, because again, we do know that there's 26,000 companies that have received a loan of 2 million or more. So while Congress is looking at the CARES 2 Act, this new round of publicity is certainly going to have them look backwards and see, are there any changes that we want to make? And then speaking of moving forwards, we still don't have a word on the forgiveness guidance. That is certainly on the 3P program, top of everybody's mind. We are exactly 4 weeks, halfway through the 8-week forgiveness period. Our sources indicated it should come this week, along with the opening of the Main Street Lending Fund. And it's Tuesday, and we're also quite anxiously awaiting that report any day now.
Well, no shortage of activity. We really appreciate your update. With that, I'd like to bring back Jack and Todd, and we will focus the rest of our time on new regulations, FAQ updates, and other activities that we're seeing on our client base. So welcome back, guys.
Thanks.
Todd, I'd like to start with you. Obviously, you work with and are connected with a lot of lending institutions. And so maybe you can give us an update on, first of all, any regulatory developments that we've seen in the past few days, as well as just what those banks are experiencing at the moment now that the PPP has reopened.
Sure, Leslie, I can do that. Thanks. I'll start off with a few updates on some programs or additional programs that have come out. As Omar said, we're still waiting on more details from that initial term sheet of the Main Street Lending Program. That comment period ended on the 16th of April. We still haven't seen updated terms, but I'm aware that the banks are talking with the Fed to try to make sure they're up to date and understand, so that can roll out as quick as possible. Because I think we're still looking at an early May rollout for that program, and that's important because it's another alternative for those who might change their mind on participating in PPP.
Sure.
Also, there's that SBA Express program. I'll just briefly cover some of the high-level terms of that, just so that people are aware. It's a pretty small dollar amount. It's got a $25,000 max on it. It's got a longer term, so it can be up to 7 years, but it's also got a high interest rate associated with it, which was prime plus 6.75%. Where could you go to get one of those if you're interested in learning more? You had to be an SBA Express lender from the lending side as of March 13th. They had to have their Form 2424 in by that time. So all these lenders that have come into this latest PPP program, they're not necessarily eligible to grant those SBA Express loans, okay? But those would be the places to turn to find out more about that program. And then lastly, I'll talk about the updates from PPP, right? As Omar said, we're still waiting on forgiveness. That's frustrating to both borrowers and lenders. Lenders need to figure out those rules and understand those rules, because that process they're involved in that process too of accepting applications for forgiveness from borrowers and passing them on to SBA. If I look at the SBA's e-trans system too, probably the best way I can analogize to trying to get for a small bank to try to get an application through that e-trans system is like trying to shove a crumpled up dollar bill into a vending machine, right?
It's just a great analogy.
A frustrating process where you put it in and sometimes it goes in halfway and comes out, sometimes it goes in all the way, but it ends up coming back out at the end and it doesn't get processed. So there's been a lot of frustration on that end. And then finally, let me touch on, I know we'll talk more about the FAQ and the question 31 about the ability to reassess, I'll say. And what I'll say from the lender side is, as a borrower, you can expect that you might receive a letter from your lender just making you familiar with the concepts of that FAQ that I know Jack will touch on some more. It's an informational piece, and I think you have to distinguish between, am I getting this, is every borrower getting this, or am I specifically getting this for a reason? And the best way I can recommend is, if you have that question, call your lender. Ask them why they were sending it. Was it a broad program? Was it something that they did in a profile that they sent it to you because of your profile? That's your first place to better understand why you might be receiving some sort of notice. Because I think in this environment, that kind of notice could generate a little bit of angst and apprehension on the part of the borrower.
That's great advice. I think there's a lot of angst and apprehension too, just because this is all moving so quickly and getting new guidance that's changing so frequently, which is a great segue, Jack, to a question for you. And that is, certainly we have seen a lot of guidance come through. So we've seen some updated FAQs. Todd mentioned in particular FAQ 31 and related regulations with that. Those are pretty significant. So maybe you can give us an update on what that means for borrowers.
Yeah, so if I can, let's just start with FAQ 31. So that came out on the 23rd last week and on the Treasury site. And it was a specific question that was asked. And so I'm just going to read it, that, do businesses owned by large companies with adequate sources of liquidity to support a business's ongoing operations qualify for a PPP loan, right? And so you're hearing about the Shake Shack rule and some of these other large public companies that took advantage of the program. I shouldn't say take advantage, availed themselves of the program. Mm-hmm. And the interesting thing was the response that they gave to this, question and answer really almost added a little bit of new criteria around the certification that the applicant had to make. So specifically, the certification was that certain economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant, right? So that was the certification that was embedded in the PPP loan application. However, what happened in this Q&A was that they added a little bit to give some clarity, I guess you could say. Now, Secretary Mnuchin said that clarity was already there today in his interview, but I think a lot of people took this as new guidance. And the new clarity was that when you're making this certification, you were supposed to take into account current business activity and your ability to access other sources of liquidity sufficient to support ongoing operations in a manner that wasn't significantly detrimental to the business. And so that could mean, your existing cash resources that create working capital. It could mean untapped lines of credits, or it just could mean if you've got a private equity firm behind you that's got dry powder, could you go to them for more funds, right? So all of this is problematic in that, companies didn't think that they were going to have to use their capital to pay payroll by bringing people back. They expected to use the government's capital to make those payroll, alternatives to unemployment. The FAQ did give a safe harbor, right? And that gets further reinforced in the interim final rule that came out the following day. But that safe harbor basically says that if you give all the loan back, and that's important because it's not part of the loan, it's if you give back all of the loan by May 7th, then you'll be deemed to have made all of your certifications in good faith and there'll be no further action against you, right? So that's important because now I know, Todd, we're going to get into this a little bit about the fraud standards and criminal standards, right? If it is an issue with forgiveness, the implication to that is your loan's there and you have to pay it back. If it's fraud or criminal, it's very different. And I know we'll get into that in a little bit. So that, those regulatory things happened in the FAQ. Then there was an interim final rule that came out on the 24th, and it kind of further went into this again, talked about the need to provide these certifications. It did talk specifically about hedge funds and private equity funds at the fund level not qualifying for PPP because those are speculative in nature. But then they did have an FAQ specific to portfolio companies of private equity funds. And again, they pointed back to the affiliate rules, which we already knew were potentially an issue for private equity portfolio companies. But then they reiterated the need to look at this economic need certification that they did, and then they formally put the safe harbor in place. So all of those things are, troubling to say the least to all companies, right? So if you're a private equity portfolio-backed company, you're really concerned about, should I take the money now? But we're hearing that same concern throughout our entire client base now, unfortunately. And they're looking at it saying, I thought I was acting in good faith, but now I don't know. And now I'm really concerned about, should I give this money back? Do I fall into that safe harbor? What are the implications to me, right?
And so what should they do? I mean, that's a big issue for people. It's a big change. What steps should we think about taking?
Yeah, and that's where we're trying to come in and come alongside our clients, right? Now, I will say that, the sufficiency of the evidence you have to support the assertions you made in your application, there's very little case law. In fact, there's no case law out there to support that yet, but that's going to be a legal sufficiency argument. So the attorneys are going to be much more useful to you than your accountants are, right? I know as an accountant, I can't give you any assurance that says, oh yeah, based on what you told me, I know you're gold. We're not going to have any problems, right? I can't do that because we just don't know. And so legally, there's going to be a process, and unfortunately, it will get adjudicated in the courts as to what legal sufficiency is there for those types of things. What we are telling our clients to do, though, is that you really need to make sure all of your assumptions and all of your state of mind was clearly documented. So when you were making that application, what were the things that you were considering? What was the economic uncertainty? What could have caused you to potentially lay off or furlough or reduce the wages of your clients? Were you really concerned about that or not? And if you were, document that whole state of mind, because those are the things that really get you to a point that says, but for the loan, I would have made different decisions, right? So I think that that's extremely important and something that, you really need to do in consultation, with legal counsel again.
Yeah, and so we've had a question come through, and it may just be back to your fact about documenting. Nellie actually asked, what if we've got an unused line of credit? Does that suddenly make us ineligible for the PPP? Because that's another source of capital. And certainly we don't want people to take it too far. But I think as we get these questions, Jack, what is your recommendation of course of action?
Yeah, I mean, like I personally go back to the name of Title I within the CARES Act, right? And it was the Keeping American Workers Paid and Employed Act, right? And so that was the purpose of that act. It wasn't there to supplement small businesses, but also small businesses weren't being imposed upon to pay people when they would have otherwise been on unemployment, right?
Right.
The purpose of this program was there. So I can't imagine that the thought was that a small business that had a $50,000 unused line of credit would have to tap that and exhaust it in order to be able to say, it's okay for me to take these loan proceeds, right? That's part of your normal working capital. And I think crafting those discussions around why that wouldn't be reasonable and why you couldn't do that and then support ongoing operations in a manner that's not detrimental to the business are going to be very important. But those are now things that, unfortunately, you have to bring into the discussion, where before I think people assumed, well, I don't need to worry about that, right? The requirement in the CARES Act to be able to seek other sources of financing and prove you couldn't get those, that was waived in the CARES Act. And I think people took that waiver as a broader waiver, perhaps. And this is bringing it back in, but again, still not insurmountable in your consideration.
That's great. So having a little bit of the framework of what that regulation said, Todd, I'd like you to talk a little bit about just what the fraud statutes might mean as well, and what consideration you give to that in light of all of these developments.
Yeah, I think Jack did a good job of summarizing kind of the risk profile. And again, I'm not an attorney, but I was just reading some articles and looking at that. I mean, I can really sympathize with borrowers who had to, everything's evolved very quickly. They had to make quick decisions. They might have looked at it at what's the worst that could happen, a low interest rate loan that doesn't get forgiven and stays on my books for a while. And now we've gone kind of 180, or the pendulum has shifted to the other side to say, now I'm reading articles that you could be, go through this whole process and in the end, because of this look back, this review, be subject to the False Claims Act. And so I think then you have to consult with an attorney and find out more about that and what that might mean and make your own decision.
That's great. So we talked a little bit about those, which I would say were significant developments and a lot to take in. And even though that is a big matter, we did get some other FAQs that came through. So Jack, maybe you can walk through what were some of the other FAQs that we saw come through this week?
Yeah. So, as part of the PPP HCE, so the CARES 3.5, we did get clarification that agribusiness enterprises and certain cooperatives were specifically scoped into the EIDL program. So that was a bit of an amendment there. They had previously been part of those ineligible businesses. So that was good to have them brought into the EIDL program. So that was probably the main one as part of the PPP HCE that passed last week. There are a few other things, though, that we're starting to get some vision into, and maybe just some things that we're hearing maybe misinformation out there about that we did want to hit on in this context. The first one of those is around the retention calculations and whether or not what full-time equivalents are, right? Now, we still don't have full guidance on this. There was an FAQ that came out on Sunday, so we know the government works on Sundays now, but the FAQ came out and did clarify that the eligibility is headcount, but the retention tests are based on FTE. Now, they stopped short, unfortunately, of defining how to calculate FTEs, but we have some guidance that's in the SBA literature from days of past that talks about a full-time person is a full-time equivalent, a salaried person is a full-time equivalent, and anybody that works less than full-time, i.e. 30 hours a week or less, then goes into the part-time bucket, and you aggregate all those hours, and then you divide by 30 to get your full-time equivalents for that part-time bucket. and then you add all those together, right? So we've got that basis in kind of older guidance from the SBA, and that was always there. The issue is not all payroll companies are doing this the same way. And so if you're getting FTE reports from the payroll companies, and when they were looking at eligibility, it was a headcount report. So they would give you one report. Then you could ask, well, I want my full-time employees. Well, that has a meaning. Over 30 hours a week, they'll give you your full-time employees. That's not your full-time equivalents, though. So you have to be very careful when asking for those payroll reports if you use an external payroll provider to make sure you're getting that data, right? And again, if you're from our conversations of past, you've got a numerator, which is your FTE count during the 8-week period, and a denominator, which is FTE count from one of two pre-COVID periods. And then depending on what that ratio is, you're going to have some of your loan that's not going to be subject to forgiveness. So those numbers are very important. The other thing, and this is just, we'll say it's a whisper out there, but it's getting to be a pretty loud whisper, unfortunately, is that 75% threshold that was thrown out in the interim final rule from back in early April. Basically, there was a thought that, there's a target of 75% of the loan proceeds being used to fund payroll costs. And for a long time, I think a lot of folks just said, okay, that's kind of a target. And the way they've put that into the forgiveness calculation is by saying no more than 25% of the forgiveness can come in the form of non-payroll costs. However, we're starting to hear now more and more frequently that potentially that 75% threshold is a gateway. And if you're below that 75%, it's possible that you would get no forgiveness whatsoever. Now, that would be, a big reinterpretation. And no, there's nothing definitive out there along those lines yet. But that would be a huge risk. So if you think about it, if you're an employer and you might not be able to get to that 75% threshold, but you're starting to bring people back and you're only going to get to 50%, now you're going to pay those folks that would have been on unemployment otherwise, and that payment is going to convert to a loan that you're going to end up paying. So now you've shifted unemployment benefits from the federal government to our small businesses. And again, I don't think that was the intention. So hopefully we'll get some clarification on that soon.
I think that's great. We're getting close to time here. So Todd, I'd like to turn it back to you for just a moment here and just ask, are there any other lending topics that we need to cover with the viewers before we wrap up today?
No, what I'd simply say, Leslie, is as a borrower, you can expect some more information requests as this process goes. We know that you're dealing with the issues of maybe looking at eligibility, determining what to do in the short term. Okay, and we know that part of that is this bad look back process that's going to occur in some form or fashion through SBA. But at the same time, I just want to say that your lenders are probably going to start asking for some information so that they can start trying to determine what the levels of forgiveness are going to be and what those remaining loan balances might look like. So don't be surprised if you get some of those communications and requests for information starting now so that they can plan moving ahead.
Yeah.
Well, this is great. And I want to thank all of you guys for your help today. We know there's still a lot of unknowns to cover for this topic in future live streams, including forgiveness guidance. And there'll be several other hot topics and other issues that arise as we all start rolling reentry here over the next couple months. So continue to reach out to your CLA advisors. Go to our COVID-19 resources page at claconnect.com. We can get you to the right person if you've got questions. With that, I just wanted to thank everybody for their time today, for your engagement on the chat, and to all of our moderators. And we look forward to seeing you Thursday this week. In the meantime, please stay safe and healthy, and thank you for watching.
Thank you.